Lucy is a YouTuber who just got her first 1 million subscribers. She was so happy that she made a video to celebrate. Luckily, a company called Zay saw the video and sent Lucy an email proposing a brand partnership. Lucy read the email and saw that she was required to accept the offer by the end of the month. She went over the details with her lawyer and sent the company an acceptance email within time. In order to get things going, Lucy went out of her way to purchase some expensive equipment which she would use to promote the company's products. However, after her purchase, she did not hear back from the company. She waited for about 2 weeks past the deadline before she decided to call the company. The company's brand manager was surprised to learn that Lucy had sent them an email accepting their terms. What had happened was that the brand manager's secretary mistook Lucy's email for spam and did not read it. This made the company think that Lucy was no longer interested and they went on to get a different YouTuber. Lucy was so disappointed. She went back to discuss with her lawyer, wondering whether she could be compensated for all the money she spent on purchasing the very expensive equipment. What is the legal position? Generally, in law, acceptance of a contract via email is valid. Except in certain cases like real estate or other formal agreements which specific laws may require additional formalities. As long as the essential elements of a contract are there, acceptance via email is legal. These essential elements are, number 1, offer, which involves the proposal of terms. Number 2, acceptance, which involves agreeing to the terms of the offer. Number 3, consideration, which means that both parties must exchange something of value. In this case, Lucy was exchanging her YouTube platform for money from the company. Number 4 is intention, which means that the parties both intended to create a binding agreement. Number 5 is legal capacity, which means that both parties must not be restricted or barred from entering into legal contracts either due to age requirements or mental stability. If all these elements are present, it means that the acceptance email, sent by Lucy, created a binding contract between Lucy and the company. The next question is, does it matter that the company did not read the email? In some cases, it matters. The answer would always depend on the circumstances of each case. The law sees communication via email as complete once the receiver has received the email. But, the law does not always require the email to have been read by the receiver. This is because, sometimes, it cannot be clearly established when the email was read. Therefore, for the purposes of business efficacy, the law leans towards reasonable expectation. What this means is that, if it can be reasonable, given the time frame and circumstances, to expect that the email has been read, then the law will rule that communication has been established and the acceptance is valid whether or not the company's brand manager read. This position is helpful because an email that is not delivered would promptly return an error message. So, to avoid the tricks and gimmicks of the business place, some countries like the UK agree that acceptance of a contract via email is valid when it enters the recipient's email server. Back to Lucy, since she resides in the UK, her lawyer wrote a strongly worded demand letter to the company and the company apologized for their error and compensated Lucy. It is always best to talk with a lawyer.
Thanks for watching. Please like, comment, share and subscribe. We value your support.